start with Joseph Reisman. What can an applicant do to increase the odds that the examiner will issue a comprehensive restriction requirement?
This is a very interesting question. Because of the protection in the U.S. of Section 121, you want a comprehensive restriction requirement separating the invention or the claim set into a number of different inventions and then serially pursue those individuals. By presenting claims of various types, device claims, method of making claim, method of using claims, presenting chemical structures in various different ways, that will elicit, generally speaking, a more comprehensive restriction requirement. You can, as well, consistent with the Manual of Patent Examination Procedure, recommend restriction requirements, although that's a less common practice. With that restriction requirement in hand, a strategy can be laid out following the principles of consonance to obtain numerous patents under the safe harbor of Section 121.
Dr. Ledwell, it sounds like a great idea to put all the claims together in a single application, but how much does that process, how much is that going to cost me as a client?
Well, actually, that's a good question. Currently, there are no government fees in Canada for additional claims or multiple dependencies, and so you have considerable latitude for developing an optimal claim set for Canada. And I've seen applications that have well over 100 claims. Typically, it would be a bit more expensive to prosecute a lengthy claim set anyway, because it would require more professional time, but you're not punished by our patent office for having the additional claims.
Dr. Reisman, what are best practices for identifying double patenting issues in a complex American patent portfolio?
Well, as I noted earlier, you do want to be careful when you have multiple patents designed to cover an identical product. Very often those patents will have overlapping coverage. Overlapping coverage does not mean necessarily that there's a double patenting problem, but it's a strong indicator. For best practices to avoid that type of problem, I would recommend in our practice is to look at the entire portfolio on a product-by-product basis, so not just patent family by patent family, and then cross-reference the various different patents, looking at them on the basis of expiry dates. If you have two patents, for example, that are set to expire on the same date, you can file a protective terminal disclaimer, or at least be prepared to do so if the patent is challenged. It is something that folks, particularly in the pharmaceutical industry, do not do often enough, and we would encourage a portfolio review to account for that.